I understand the arguments that Mr. Hampe is making to revisit the court's earlier findings of fact and conclusions of law. But what I see as being the gist of the argument now is about the mental exam. There was a mental exam that was ordered in a circuit court case that suspended those proceedings. There was basically an agreement here in the district court that pending the return or results of that mental exam, it was inappropriate for the court to schedule a trial for Mr. Pinkerton in the case. And so there was an agreement by the defendant through counsel that the time delay that occurred between the trial date that was set in December to whenever it was going to be reset was going to be excludable time because of the need to see what happened on the mental exam in the circuit court case. That was agreed to, except if the state caused extraordinary delay in connection with the circuit court mental exam. At some point in time, when the state did the order or communicated with the examining doctor in the circuit court, the court understands this. What's being argued is that Deputy Prosecuting Attorney Guyot told the doctor, just do your report on the issue of fitness to proceed. Don't answer any other further questions. So if the defendant is fit to proceed, that's all you say. You don't do any finding or any opinion on cognitive or volitional capacity. The Deputy Prosecuting Attorney, it is argued, did not have the authority to do that and should not have done that. That was within the purview of the court. Because that limiting order or directive was given by the state, it necessitated a delay in getting results on the mental exam as originally conceived. So there's a question of how much delay was caused because the doctor then had to go back and take some extra time to then furnish opinions on the other issues such as cognitive or volitional capacity. The court understands that that is an issue. So one question I have is whether or not the state is disputing that there was some amount of time that translated into delay in receiving the final opinions of Dr. Samsel in the circuit court because there was a directive made by the Deputy Prosecuting Attorney in that case that the doctor initially should only limit his opinions to fitness to proceed. Is the state disputing that?
Yes.
So what is the state saying in terms of, the state is saying that it made no difference because the return date that was set in the circuit court was the same in any event?
Yes.
And when was the original return date that was set?
Your Honor, I don't know.
Well, why don't you know?
That was before I was even with the office.
You know what?
Stop
right now. Stop right now, because I can feel myself getting hot behind the collar. You know what? I'm here. I take the time to review the motions. I take the time to review the pleadings. This is on calendar. You guys continued it once already. I come into the bench. I assume that I'm going to get some arguments and get some evidence for which I can actually make some findings and make a ruling. And it's not acceptable to me that the prosecutor that's assigned to do this motion is not telling me, I don't know.
My instructions from Mr. Guyot was to stand on the motion and not argue the case. I sit here in court this morning and hear Mr. Hampe stand up and ask the court go behind a prior ruling in 06. Go completely behind it. My understanding, you made a ruling in 06.
Okay, but
now he's asking you to go behind that.
But we're in 07. Okay? Stop. We're in 07, and let me tell you why I'm upset. We're in 07, and the motion that's been filed deals with issues other than what was decided when I made a decision in September of 06, and that's what I'm asking you about.
I understand that. But part of what happened this morning is what I heard, defense counsel asked the court. My instructions from Mr. Guyot were to stand on the motion as filed. If you want additional information, our office will provide it. I will get a tape of this proceeding and give it to Mr. Guyot, and we can continue. I don't have that information in hand.
Let me see if I get this straight. We have a motion hearing. There was a motion that was filed. There was a memorandum in opposition to the motion that was filed. And that memo was filed on July 9th. And granted, it was signed by Marc Guyot. But you're standing and appearing on behalf of the state today And let me ask then, the state is now being given an opportunity to make whatever argument or objection or opposition it has to the motion at this time. Do you have anything above and beyond what was contained in the memorandum in opposition on July 9, 2007, in opposition to the defendant's motion? If you do, you may make the argument now. If you require more time, you make a request now. Anything further from the state?
Well, given the option of saying I have nothing further and to stand on the motion based upon the statements of Mr. Hempy, I would ask that we be given a short period of time, a very brief period of time, where this hearing and the videotape from this hearing can be presented to Mr. Guyot and let him respond. He's totally familiar with this.
Why,
I'm not.
If Mr. Guyot is the one that knows and you want him to argue, why isn't he here in court today? Why are you here?
Because that was what he wanted me to do.
Then you're responsible.
I understand.
So you're the responsible attorney. You represent the state. Do you have anything further that you wish to argue in opposition to the motion?
Not at this time.
Are you requesting a continuance, and if so, for what specific purpose?
For the purpose of addressing the questions you just put to me about the status of the circuit court matter and whether Mr. Guyot would admit that he delayed the proceedings by asking the doctor not to proceed on volitional.
Or are you disputing that he told the doctor only do the fitness to proceed? Are you disputing that?
I think there is a statement by Mr. Guyot.
That's a pretty simple question.
I know. But these are all matters that did not involve me personally. There is a statement in the memorandum in opposition I read a statement that the state had inadvertently asked for something in addition, but I don't see it in the...
The question of the court is the state disputing that Deputy Prosecuting Attorney Guyot told Dr. Samsel, you only have to do the report on the issue of the fitness to proceed? Are you disputing that? I'm not asking about delay. I'm asking whether you're disputing that statement.
I have no personal knowledge of what Mr. Guyot told the doctor.
I don't... So what is that? Yes,
for
no?
the record, I would have to dispute it and give him a chance to respond to that.
Okay. But you're not prepared to respond other than the filing?
No, my marching orders were to stand on the motion as the memorandum.
Okay, this is what the court's going to do. The court has received the defendant's motion to dismiss. The court has received the state's memorandum in opposition. The state has indicated through its deputy prosecuting attorney, Mr. Meridian, that his marching instructions were to come to court today and stand on that memorandum in opposition. Based on that, the court will take as complete and final opposition to Mr. Pinkerton's motion the state's memorandum in opposition. Based on that, the court's going to issue some findings and conclusions which are going to include the fact that the state has not met its burden given its opposition filed in writing, and the state's going to grant Mr. Pinkerton's motion to dismiss the matter. And the state's going to grant it with prejudice.